My name is Ghulam Sakhi. I am a research director at Afghanistan Human Rights and Democracy Organization. I'm moderating today's webinar on non-state armed groups and international humanitarian law. This webinar is part of a broader series of expert discussions on justice, tolerance, and sustainable peace building in Afghanistan. Our speaker for today is Nima Melani Nia. Nima is a distinguished international lawyer and international scholar. He has worked previously in various senior capacities with the International Criminal Court as well as with the International Criminal Tribunal for the former Yugoslavia. Currently, Mr. Melani Nia is an advisor for the Center for Climate Crime Analysis. It is a great pleasure for having Mina today as a speaker at this webinar. Before I give the floor to Mr. Melani Nia, let me just briefly unpack the objective of today's webinar. First and foremost, in this webinar, we are trying to explain what IHL rules are applicable to non-state armed groups during an armed conflict. Second, what rules and mechanisms could be used by non-state armed groups to implement relevant international rules. Third, how could violation of IHL rules be addressed during and as well as after an internal armed conflict? On the logistics of this event, our speaker will speak for roughly for 30 minutes, and then we will have questions and answers for another 30 minutes following that. Unfortunately, our participants will not be able to engage directly with us. They can share their questions through a participant box at the bottom of the webinar page, as well as there is a chat box. You can share your questions with us both in English and Dari, and then we will get those questions to our speaker. This webinar is also being aired through our Facebook page, so you could share your questions and issues of importance to you on our Facebook, and then we will share that with our speaker. Without any further ado, I would like to ask Mr. Nima Melania to start his presentation.
Before I begin, let me give my thanks to the Afghanistan Human Rights and Democracy Organization. I think this platform is not only essential, but it's critical for our times, especially in ensuring that there is a common understanding of what human rights and international humanitarian law has to say with regards to the conduct of conflict, but also in the conduct of peace. And to the extent that these are one of a series of different lectures on what those parameters are, they are essential, and I'm incredibly grateful for the organization to provide me this platform to hopefully assist in your understanding of these principles, and of course to answer any of the questions that you may have. As has already been mentioned, my discussion will be limited to the roles and responsibilities of non-state armed groups under international humanitarian law. And my goal is to provide a general outline of the responsibilities and obligations that those groups have under that law. So to do that, I intend to advance this presentation and this discussion in the following ways. First, I'll engage in a discussion with regards to the applicable legal framework. And by this, I mean what laws govern these responsibilities that we are discussing today. Second, I'm going to describe when these laws apply. And by this, I mean, in particular, when does international humanitarian law apply? Third, I'm going to briefly outline then what these responsibilities by non-state armed groups are under international humanitarian law when it does apply. And then finally, I'm going to briefly discuss criminal responsibility for the violation of these responsibilities or these obligations. Before I begin, however, I think it's important that we have two general understandings, or that I make two brief comments. First, I think it needs to be understood that this is a preliminary discussion. Many of the concepts I will be discussing are complex and have significant depth. And given our limited time, I won't be able to go into those complexities. But if you have specific questions, obviously I'm happy to answer them at the end, or even after this presentation, if you wish to do so by email. Second of all, what we are talking about today is obligations under international humanitarian law. And I say that with emphasis because that limitation is important. International humanitarian law, as I'm going to discuss in depth more soon, is limited to situations of armed conflict. So we are not talking about, for instance, the roles and responsibilities of non-state armed groups under other bodies of law, such as, for instance, international human rights law. And I want to make sure that we're not confused with other international or domestic laws, which may also create obligations and responsibilities for non-state armed groups. So for instance, international human rights law, which typically applies during times of peace, but also applies during times of war, generally creates obligations for states, but can also create obligations for non-state armed groups in circumstances where those groups exercise certain levels of control over a particular territory. And then, of course, there's obligations under domestic law. So in the context of Afghanistan, under Afghan law, which creates complementary obligations and responsibilities for non-state armed groups that may go beyond what is mandated and required under international humanitarian law. So it's very important that we understand that the discussion today will be about obligations under international humanitarian law, but there could be obligations that arise under other bodies of law which would supplement these obligations and responsibilities that we are discussing today. Now, when I talk about international humanitarian law, I think it's important that we understand what that necessarily means from the standpoint of what the legal framework is. In general, the rights and responsibilities of all parties during conflict, and by conflict I mean an armed conflict, are governed by international humanitarian law. And in general, when we're talking about international humanitarian law, we are referring to the rules and obligations that arise from three bodies of law, which are depicted in this slide before you. And that would be, first and foremost, the Geneva Conventions of 1949, which are four conventions or four treaties that were established in 1949, and three additional protocols that establish the standards of international law for humanitarian treatment in war. I won't go into specific depth as to what each one relates to, but in general, the four Geneva Conventions relate to the rights and obligations of different armed groups or different parties to a conflict as it relates to certain categories of persons. So for instance, the first Geneva Convention relates to the conditions of the wounded and sick in armed forces. The second deals with the condition of wounded, sick, and shipwrecked members of armed forces at sea. The third concerns the treatment of prisoners of war. And the fourth concerns the protection of civilian persons during times of war. The additional protocols, the first two, which were passed in 1977, and the last one, which was passed in 2005, add additional protections. For our purposes, it is the second one that is the most important because it concerns the protection of victims during non-international armed conflicts. And I'm going to discuss that in a second because non-international armed conflicts are primarily the forum in which international armed groups, non-state armed groups are typically active in. And although war has changed dramatically since the Geneva Conventions. They are still considered to be the cornerstone of contemporary international humanitarian law. So for our purposes, they will always be the guiding principles through which this discussion will take place. Second, we have the Hague Conventions of 1907. I'm not going to discuss those in depth. In general, while the Geneva Conventions lay out the rules for protecting people during war, the Hague Conventions set out the rules for conducting war. And then finally, within the framework of international humanitarian law, we have customary international law. And in simple terms, customary international law are legal principles that are generally accepted across all states as reflected in their domestic law and domestic practices. And in the context of international humanitarian law, often what happens is courts, international courts in particular, look at the practices of states during active conflict or as depicted in their military manuals, and from there derive what they believe to be general principles that are applied or adopted by all states. For an understanding of what is customary international law, especially in the context of war, some of the best sources are the judgments of the different international criminal institutions, such as the International Criminal Court, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and the Special Court for Sierra Leone, as well as other international criminal courts, which oftentimes, in determining some of the obligations of different actors to a conflict, will engage in this analysis and describe what is customary international law. But for our discussion, I'm not going to per se discuss customary international law. Again, as I mentioned before, I'll be focusing on what the obligations are arising out of the Geneva Conventions. Briefly, it is also worth noting that while international human rights law is a separate body of law, in principle, it doesn't cease during armed conflicts. And as I mentioned before, may create additional rights and obligations separate from international humanitarian law. And those rights and obligations are provided for in various human rights instruments, such as the Universal Declaration of Human Rights, the United Nations Charter, and obviously other specialized human rights treaties. So the question then is, when does international humanitarian law apply? And in the most simplistic terms, international humanitarian law only applies in the situation of an armed conflict. And more specifically, it only applies in the context of two different types of armed conflict because it only recognizes two different types of armed conflicts. And one is, and you'll hear this often in the vernacular of international humanitarian law, which is international armed conflicts, and then non-international armed conflicts, or otherwise also known as international conflicts of a non-international character. International armed conflicts are conflicts between two or more states. Non-international armed conflicts are conflicts between a state and an organized non-state armed group. What is important to also understand is that in any given conflict, there could be elements of it that are international, and there could be elements of it that are non-international. So for instance, if we take Afghanistan, for instance, there had been historically circumstances where there was at the same time a conflict between the Afghan government or the forces of the Afghan government and the forces of another state, but at the same time also a conflict between forces of the Afghan government and non-state armed groups operating within the territory of Afghanistan. We have also seen this most recently in the conflict in Syria, where you had simultaneous conflicts between the government armed forces in Syria versus armed forces of other states, and obviously between the Syrian armed forces and organized armed groups operating in Syria. In determining what rights and obligations apply in those circumstances where you have simultaneous conflicts going on. It depends on which of the conflicts that conduct is connected to. We're not going to go in depth about that, but I did want to demonstrate that it can, in certain circumstances, become slightly complicated, especially when we're discussing which conflict certain conduct can be attributed to. Now, these distinctions between whether or not the conflict is international or non-international is important for two reasons. First, what triggers an armed conflict depends on whether or not the conflict is international or non-international. And then second of all, the scope of obligations and the scope of duties that arise are also dependent upon international or non-international armed conflicts. The second issue is slightly more complicated because there is at least some jurisprudence, in particular from the International Criminal Tribunal for the former Yugoslavia, which suggests that all of the obligations that arise in international armed conflicts as a matter of customary international law apply to non-international armed conflicts. But that position is still debated. It is not the position, for instance, of the International Criminal Court, which has more rights and responsibilities outlined for international armed conflicts than for non-international armed conflicts. And it is also not the circumstance as depicted under certain military manuals and in the Geneva Conventions and their additional protocols. I'm not going to opine on that debate, and I'm not going to get into depth about it, because for the most part, our discussion will assume that there is a non-international armed conflict, since that is the predominant form of armed conflicts today, especially in which organized non-state armed groups operate in. Now, as I mentioned before, what triggers an armed conflict depends on how we characterize the armed conflict itself. In particular, what triggers an international armed conflict is very de minimis. It simply requires the taking up of arms by one state against another state without any further qualitative requirement or even quantitative requirement behind the taking up those arms. In contrast, in a non-international armed conflict, what is typically required is quote unquote protracted armed violence between the government authorities and the organized armed groups, or between armed groups operating within the territory of the state. And that's something that's important to understand, which is the non-international armed conflict can also be between the groups operating within the state. And that threshold of a protracted armed violence is one that was established by the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia as reflecting customary international law. Now, the reason why you have a higher threshold of violence for purposes of non-international armed conflicts than for international armed conflicts is because there is an aim under international humanitarian law to distinguish armed conflicts versus internal disturbances or tensions, which are not armed conflicts. So for instance, the framers of the Geneva Conventions, as well as militaries around the world, have constructed these provisions to make sure that there is a distinction between when we classify something as an armed conflict versus domestic violence by organized groups, such as by gangs, by mafias, or by other organized criminal entities, which would not be armed conflicts, but would simply fall within the parameters of domestic law. That's the first thing I think is important to note. The second thing I think is important to note is that for our purposes, as to when international humanitarian law applies, motive and intent are irrelevant. In other words, why a non-state armed group is trying to displace the incumbent state is immaterial from a legal standpoint. It doesn't matter whether or not their objective is religiously motivated, whether it is politically motivated, whether it is economically motivated, for determining whether or not international humanitarian law applies. Under international humanitarian law, the critical question is what is happening and not why and wherefore. And that is essential, I think, for understanding the application of international humanitarian law. So what do we mean then by a non-state armed group? And this is also important to understand, which is that there is no definition of a non-state armed group within any international treaty. The closest definition that we have is provided for you in this screen, which is from Additional Protocol 2, which, as I mentioned before, applies to circumstances of armed conflicts of a non-international character, so non-international armed conflicts. And there, it provides under Article 1 the fact that, and you can see this in the text that is provided for you, that it is a conflict between a state's armed forces and dissident armed forces or other organized armed groups under responsible command, which exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol. Now, this is important because as you can see, there is a certain level of organization that Additional Protocol 2 applies to armed groups for them to rise to the level of a non-state armed group for determining whether or not they are bound by the obligations under Additional Protocol 2. As we're going to discuss in a minute, this is different from other provisions of the Geneva Conventions, in particular Common Article 3, which creates rights and obligations to any party in the conflict, irrespective of whether or not that party is organized or not, or can exercise such control over a territory or not. So there is that important distinction, which I think is crucial to understand. In addition, I think what is important to understand is that this notion of what is an organized armed group has received attention by the different international criminal courts, as well as by different international bodies, such as the ICRC, the International Commission for the Red Cross, which have tried to give further explanation and parameters for what an armed group is for purposes of international humanitarian law. For instance, in the Haradinaj case before the International Criminal Tribunal for Yugoslavia, that trial chamber found that an armed group must be characterized by the existence of a command structure and disciplinary rules, the existence of headquarters, control over a certain territory, the ability to gain access to weapons or other military equipment, recruits, and training, the ability to plan and coordinate, the ability to define a unified military strategy, and the ability to speak with one voice. And the reason why the ICTY, as well as other institutions, have provided such strict standards of organization is because from their point of view, unless there is an organizational structure for the armed group, it is impossible for them to carry out the obligations that are provided for under Additional Protocol 2, and therefore that necessary requirement of organization would be required to be able to carry out those obligations. But we're going to come back to this distinction in a moment, because even where there are circumstances where that organization or that level of control does not exist, there are still rights and obligations that the non-state armed group still has towards the civilian population in particular. And that actually leads me to my next slide. So this slide begins discussing the responsibilities of non-state armed groups. And the key point here is that non-state armed groups are bound by the laws of armed conflict. The excerpt that you see in front of you is from the appeals chamber of the Special Court for Sierra Leone in the Prosecutor versus Norman case, during which it states very explicitly that it is well settled that all parties to an armed conflict, whether states or non-state actors, are bound by international humanitarian law, even though only states may become parties to international treaties. And then it goes on to state that customary international law represents the common standard of behavior within the international community. Thus, even armed groups hostile to a particular government have to abide by these laws. Therefore, no matter what, armed groups, be they state or non-state, must be bound and must respect the laws of armed conflict. This understanding is also, as I mentioned before, reflected in Common Article 3 of the Geneva Conventions, which states, and I quote, "In the case of armed conflict, not of an international character occurring in the territory of one of the high contracting states, parties, each party to the conflict shall be bound to apply as minimum the following provisions," and then it provides those provisions. And then occasionally the United Nations Security Council also reinforces the fact that every party to the conflict is bound by international humanitarian law. So for instance, in United Nations Security Council Resolution 1564 concerning Darfur, the Security Council noted that all of the armed groups, including rebel forces, must ensure that their members comply with international humanitarian law. Now, the responsibilities of non-state armed groups under international humanitarian law vary depending on the qualification of the conflict, the level of organization of the group, and their capacity to exercise territorial control. And I say this because the level of organization and the capacity to exercise territorial control might implicate additional rights and responsibilities given the nature of that control. So for our purposes, the best way to, I think, view the rights and responsibilities of non-state armed groups is to understand that they arise from three different categories, which are Common Article 3, as well as Additional Protocol 2, depending upon the level of organization, international human rights law, again, depending on the level of organization and territorial control, and respect for domestic law, which applies in any context. If you want, we can address this more in detail during the course of questions. In general, Common Article 3 of the Geneva Conventions provides minimum guarantees of humane treatment that apply irrespective as to the organization of the armed group or its level of territorial control. In other words, these are protections that apply under all circumstances to all armed groups, regardless of how formalized or organized they are. Common Article 3 sets out what we consider to be mandatory obligations and minimal guarantees for parties to a conflict, whatever their nature. And the essential rule of Common Article 3 is the requirement of humane treatment and without adverse distinction. And you can see excerpts of Common Article 3 here before you. The article then describes some of those prohibitions, such as killings, mutilations, torture, and the taking of hostages. And then you can see there are broad categories such as outrages upon personal dignity, which have been defined to include, for instance, the prohibition of sexual violence, including rape and enforced prostitution, as well as humiliating and degrading treatment. Common Article 3 also provides the right of an impartial humanitarian body, such as the International Committee of the Red Cross, to offer its services to each party to the conflict, and that would obviously necessarily include to the non-state armed group. Now, some things to bear in mind, which is while this may sound all-encompassing and quite broad, these provisions only apply to two specific categories of persons, these protections that is. One is those who do not take part in the active conduct or active part in hostilities, and that would necessarily mean civilians, and those who do not take active arms against the state. And second, those who, having taken part in the fighting, are hors de combat. And in simple terms, what that means are persons who have expressed a clear intent to surrender, even if they were participating in the armed conflict. Further, another thing that's important to understand is that humane treatment of captive insurgents, so humane treatment of hors de combat, does not mean that they cannot be prosecuted or even sentenced to death. In fact, they can, including for their mere participation in hostilities. The only condition under Common Article 3 is that the sentence be delivered by a, quote, regularly constituted court following a fair trial afforded all of the judicial guarantees. So this is important to understand because in the context, at least, of a non-international armed conflict, insurgents or members of a non-state armed group are still punishable by law, that is domestic law. Additional protections are also provided for by Additional Protocol 2 of the Geneva Conventions. And while Additional Protocol 2 complements Common Article 3, it's important to understand that it has a narrower scope in the sense that it only applies to circumstances where the armed group has a specific threshold of organization and control over a territory, as I mentioned before. However, assuming that Additional Protocol 2 is implemented, or is implicated, it provides certain levels of rights and responsibilities in addition to the ones that are provided in Common Article 3 that can fit basically within three categories, which are additional protections concerning humane treatment, additional obligations toward the wounded, sick, and shipwrecked, and additional obligations toward the civilian population. So Additional Protocol 2 prohibits, importantly, all acts of violence against life and persons. It expressly prohibits rape, enforced prostitution, and any form of indecent assault. It prohibits pillage and any attacks on property. It requires requires all parties to the conflict to respect the convictions and religious practices of civilians under their control. It requires them to take special care not to damage or destroy cultural property. It provides a legal protection or a legal framework, for persons deprived of their liberty and prohibits the passing of sentences without a fair trial. It provides rules protecting displaced persons. It protects the civilian population from being attacked and prohibits the group from spreading terror among the civilian population. It establishes a framework regulating humanitarian assistance for the civilian population. It requires parties to the conflict to collect, to protect, and to care for the wounded and the sick, and it protects the continuous education of children. And these are just to name a few. It's quite a comprehensive set of obligations. And the special protection of children is a particularly important part of Additional Protocol 2, because the framers of Additional Protocol 2 were concerned about the use of child soldiers in the context of non-international armed conflicts by non-state armed groups, as was endemic in a number of conflicts in sub-Saharan Africa, such as in the Democratic Republic of the Congo, or in the Central African Republic, or even in Sudan in the context of Darfur. So there are special protections that are afforded to children that are quite expansive and as defined in Additional Protocol 2. And this brings me to the last point I wanted to discuss, which is criminal responsibility. Violence and crimes during non-international armed conflict is often rampant and can be prosecuted under a variety of different criminal laws. But for our purposes, I'm going to simplify what those are. First is they can obviously be prosecuted under domestic law. Domestic law continues to apply during armed conflicts unless there is a provision within the Constitution or other laws and treaties of the state which create exemptions or derogations from domestic law. But in general, a non-international armed conflict likely continues the application of domestic law such that all acts of violence committed by the non-state armed group will be considered a crime, typically under domestic law. And this includes the killing of soldiers or the police belonging to the state. Now, in contrast, that's important to understand because typically the killing of non-state armed group members by the government armed forces or by law enforcement agencies are unlikely to constitute domestic crimes since they are typically permitted under domestic law. So importantly, and this is a key to understanding the application of domestic law, the outbreak of a non-international armed conflict generally does not seize the application of domestic law and its application to non-state armed groups. War crimes is contrasted from domestic laws in the sense that they concern serious violations of the laws of war. Importantly, an act of violence is a war crime if it is prohibited under the laws of war and there is a connection or nexus with the armed conflict. Now, when I say prohibited under the laws of war, the most comprehensive list of what that means is Article 8 of the Rome Statute of the International Criminal Court, which includes a variety of obligations broken down by whether the conflict is international or non-international as to what constitutes a war crime. And they include violations of Common Article 3, the minimum guarantees that I provided for. And they also include many of the prohibitions provided for in Additional Protocol 2. But it's important that they don't provide all of the prohibitions provided in Additional Protocol 2. So for instance, acts of terrorism, which are provided for in Additional Protocol 2, are not criminalized under Article 8 of the Rome Statute, nor is the improper use of the Red Cross emblem, and nor was the act of starvation until last year when the Rome Statute, 2 years ago, when the Rome Statute was amended to include starvation as a crime under non-international armed conflicts. So that's important to understand, that all of the obligations that arise under international humanitarian law are not one-to-one also criminal violations under international criminal law, and that there are some differences and discrepancies between the two. And then finally, there's the application of other international crimes, in particular, crimes against humanity and genocide. Importantly, these are international crimes that can apply during times of peace as well as during times of war. And there is no requirement that there be a nexus between these crimes and an armed conflict. Crimes against humanity have a separate nexus, which is that the act, so for instance, the killing, or if it's a crime of sexual violence, be connected to a widespread or systematic attack directed against a civilian population. Genocide, on the other hand, concerns certain acts like killing or serious bodily or mental harm that is committed with a specific intent to destroy in whole or in part a certain protected category of people, such as racial or ethnic groups. So these are crimes that are not synonymous with war crimes because they don't need to happen during war. However, these are crimes that can happen during war, as we saw, for instance, in the former Yugoslavia, where we had war crimes that were committed in addition to crimes against humanity, but also in addition to the crime of genocide, such as what happened in 1995 in Srebrenica. Similarly, during the Second World War, we obviously had war crimes, but we also had the commission of other international crimes during the conflict, including crimes against humanity and genocide. So this concludes my discussion for now. Obviously, as I mentioned before, we try to discuss these issues in general terms to give you an understanding as to the framework, as to the rights and obligations of non-state armed groups. But I'm happy to go into depth with regards to any one of the points that I mentioned before to give you greater clarity as to what they might pertain to. And for that, I'm open to any questions that people may have.
Thank you very much for your fantastic presentation. I've got a number of questions in relation to implementation of IHL by non-state armed groups. So the first question is, since non-state armed groups are not party to conventions, so what processes or mechanisms do they use in order to start their compliance with IHL? And second, related to that is that what mechanisms and processes could be used by non-state armed groups in order to implement IHL rules and principles applicable to internal armed conflict. And the third point in relation to this is what mechanism could be used internationally in order to encourage non-state armed groups to comply with OIHL rules and principles.
Sure, I'll start. I'll take the questions in turn. The first question, as you mentioned, concerns the point that I raised, which is even though armed groups are not party to international treaties, they're still bound by the obligations provided for under international humanitarian law. Now, the scope of responsibilities and the scope of rules that they're bound by depends, as I mentioned before, on the character of the armed group in particular. But irrespective, as I mentioned, there are minimal guarantees that requires humane treatment of civilian populations without adverse distinction that are provided for in Common Article 3 of the Geneva Conventions, which applies irrespective of the armed group's characteristics or, importantly, organization. So really the question is, what additional rights and responsibilities do armed groups enjoy? And that is what is provided for in additional Protocol 2. And the answer to that question depends largely upon how organized the armed group is and the threshold of organization required by the body who's making that assessment. So as I mentioned before, the International Criminal Tribunal for the former Yugoslavia has quite specific thresholds for organization before these additional rights and obligations can be found or can be imported onto the armed group. Whereas there's other legal treatises that might have lesser levels and requirements of organization for those rights and obligations to apply. Now, the second and third questions that you raise principally concern with how do these armed groups then respect international humanitarian law? What can they do both within the nature of the group, and then obviously what can international institutions do in order to compel armed groups to respect international humanitarian law? Now, under the first, there's a variety of different things that armed groups can do. They can apply standards of conduct that are implemented internally to ensure that there is compliance with Common Article 3 and the obligations posited by additional Protocol 2. And that can be done in writing, it can be done orally. There are systems of command to ensure that violations of these provisions are prevented and punished and disciplined in accordance with minimal standards of fair trial. And there's obviously training that can be undertaken and provided for with the cooperation of international institutions like the ICRC or the Red Crescent Society in order to ensure in order to ensure compliance with international humanitarian law. And we've actually seen in a number of circumstances non-state armed groups undertake exactly these types of steps. So for instance, in the conflict in the former Yugoslavia, many of the non-state armed groups there had their own codes of conduct that intended to comply with or to pattern the obligations under international humanitarian law. And they also permitted training by international bodies like the ICRC. And then finally, with regards to what international institutions can do, there's a variety of steps. One is obviously condemnation. So as I mentioned before, the Security Council has, in a variety of different resolutions, reminded every party to the conflict, including non-state armed groups, of their obligation to comply with international humanitarian law. We have international institutions which also provide training to these armed groups, including through embedding themselves with these organizations to ensure that there is respect for international humanitarian law. And then there's the punitive aspect of things, which is requiring compliance through punishment. And that is fundamentally where the international courts have come into play, which is in many cases, the International Criminal Court and the International Criminal Tribunals have held individuals responsible for armed groups for criminal responsibility for their failure to comply with international humanitarian law and for failing to protect and punish civilians from these minimal guarantees or from the additional requirements provided for under Additional Protocol 2, which are obviously criminalized under their statutes. And thus through criminal punishment, we have deterrence. So these are, I would say, the three main ways in which international institutions can ensure compliance with international humanitarian law by non-state armed groups operating within whatever territory that they're operating
Thank you. There's one question, OIHL and national criminal laws. As mentioned under OIHL, under national law, act of violence itself is an offense and it's therefore punishable. But under OIHL and international law, that's a bit different. Act of violence itself does not per se constitute a crime. In this specific case, how do national laws complement OIHL rules and principles?
Yeah, it's a very good question. And I think I need to take a step back. Under international humanitarian law, there's what's called the combatant's privilege. And I think it's important to remember the difference between war and the difference between peace from a very simplistic sense that obviously during times of peace, we make it prohibited that anyone can kill another person, obviously with the exception of the importation of the death penalty, where there's the commission of certain crimes, and there's sentencing in accordance with fair trial rights. But in general, we make it a rule that nobody can kill another person. Now, during times of war, that rule, which is that respect for the right of life and the firm prohibition against killing, is not, I wouldn't say limited, but changed such that there is a privilege given to, or a protection given to armed forces to kill combatants on the other side without being prosecuted for that killing. In other words, if two militaries meet and soldiers from military A kill soldiers from military B, the soldiers from military A would not be criminally responsible for killing the soldiers of military B because that is occurring during the time of war, and that act is permitted or privileged under the laws of war. And that's what we mean by a combatant's privilege, in the sense that a combatant has the privilege to kill combatants on the other side during a time of war. Now, that is absolutely the case during international armed conflicts and in conflicts between states. However, in non-international armed conflicts, the same privilege does not apply to acts of violence committed by members of the non-state armed group. That is to say, members of the non-state armed group don't have the same privileges as members of a state's armed forces would in the context of an armed conflict, which means that a member of the non-state armed group can actually be prosecuted and sentenced for killing an armed member on the other side, be it a police officer or a soldier, under domestic law. And not only can they be punished for it, but they can be sentenced in accordance with law, which is they can be subject to the death penalty, given the fact that many countries around the world still continue to have the death penalty for acts of killing. So that is still permitted. And that distinction, I think, is important to understand. And then within that, however, what's important to understand, though, is that there are certain fair trial rights that must be provided to the combatant of the non-state armed group when they're detained by the state. And typically, in general, that means they must be provided, or they must be brought forward a regularly constituted court and provided fair trial rights and due process rights that are compliant with what we understand them to be under international human rights law. They're not specified under the Geneva Conventions. There are greater due process specifications under the additional protocols. And therefore, for understanding, however, we do tend to resort to international human rights law.
Thank you. There are a number of questions about tackling uh, uh, the violation of IHL committed by non-state armed groups. And there are questions about the timing of tackling those crimes committed, as well as about the processes and mechanism. Since Afghanistan is on the verge of starting peace negotiations with the Taliban, so it's an important issue. It will be great if you could provide us with some comments on modalities of addressing crimes committed by non-state armed groups, as well as some ideas and points in terms of timing on when is really the best time to address those issues, whether it is during a negotiation process or after a peace agreement is signed, and then in a post-peace agreement environment where there might be more opportunities for a more sober discussions.
Yeah, those are also excellent questions, and we could spend a lot of time, I think, discussing both of those questions. So, and with the respect toward time, I'll keep my comments brief. With regards to modalities, there's obviously a number of different ways in which those acts can be held accountable for. Obviously, there is responsibility via the international forum, and that can take a different that can look a number of different ways. So, for instance, prosecution before the International Criminal Court, prosecution before a specialized UN body if one is created, prosecution before a hybrid body, so a body that is comprised of both international jurists but also national jurists. There can also be prosecution domestically. That can be done either through the regular courts. So, for instance, the regular criminal courts. It can also be done through specialized courts, such as the War Crimes Court, or through any other regularly constituted court that is established under law. And then even beyond prosecution, we've seen circumstances where violations of IHL have been addressed through other mechanisms, such as through peace and reconciliation committees. So in the context of Rwanda, for instance, we had, apart from prosecutions by the domestic courts and the International Criminal Tribunal for Rwanda, we had gacaca courts, which were tribal courts that were put together in order to provide truth and accountability for the conduct of others. And the reason for that, obviously, is that in conflicts where you have many crimes committed over a period of time, it may be impossible to actually hold everyone criminally responsible who has contributed or committed a crime during that conflict. And therefore, other mechanisms are established to allow for truth and accountability or truth and reconciliation, while also permitting criminal responsibility for senior leaders or for those most responsible for the commission of those crimes. So I think in sum, there's a variety of different mechanisms that are available. And I should also add that this isn't it's not a circumstance whereby only one mechanism is often the suitable mechanism for addressing a case. And oftentimes nations and communities resort to different mechanisms in order to address rights and responsibilities by different elements or by different levels of persons contributing to those crimes during the conflict. So they may decide to have those who are leading these armed groups be held criminally responsible using international tribunals or domestic courts, whereas more lower level figures who are combatants undergo the peace and reconciliation process and therefore be immune or get privileges from criminal responsibility. So there's a panoply, or there's a variety of different mechanisms that can apply at the same time. Now, in terms of when is the right time, that is also contextual. From a criminal liability standpoint, the when is the right time often broaches the question as to whether or not there's an applicable statute of limitations. And a statute of limitations would be a statute which bars criminal responsibility after a period of time in which the act is detected or the act is committed. In general, these types of heinous crimes, especially international crimes, don't have a statute of limitations. In other words, they can be criminally prosecuted at any time after their commission, even if it's 10 or 20 or 30 years after they've been committed. Now, domestic law, however, might apply differently, and there might be a domestic statute of limitations which bar criminal prosecutions after a period of time. And I'm not going to discuss that, but I'll just. However, when you might want to undertake these remedies might be implicated by certain practical circumstances, such as if you do want criminal responsibility. Oftentimes in investigation and prosecution, the golden rule is to have those very close in time to when the criminal act occurred, because evidence can be lost very quickly, witness memories fade very quickly, and certainly over a period of time. And so the golden rule is to have prosecutions and investigations very close in time to when the act occurred. So to give you an example, the investigators who investigated the genocide in Srebrenica in 1995 were on the ground within days of the genocide occurring, and that allowed them to collect incredibly valuable information with regards to the genocide itself, which they then brought for prosecution before the International Criminal Tribunal for the former Yugoslavia, and then also before domestic courts. So I think from a criminal law standpoint, it's essential that there is a fully functioning investigative body that is constantly collecting evidence, contemporaneous, if not simultaneous, to the commission of crimes, so that the evidence is not lost. And then absent that there are organizations on the ground who are doing that work to preserve the information for the prospects of criminal prosecutions. So, for instance, in Cambodia, we had many civil society organizations which were active in terms of collecting information concerning the crimes committed by the Khmer Rouge. And that evidence was used later on, decades later, by the ECCC, the hybrid criminal tribunal, which then prosecuted those crimes for individuals at the senior level. So, those are some issues that need to be taken into consideration for deciding when to implement certain aspects of or certain modalities of responsibility, and certainly need to be factored into when criminal responsibility is considered as a viable option, especially to preserve information for purposes of viable and effective prosecutions. But this is a topic that obviously takes into consideration a whole host of other factors as well that we can discuss, but within the limited period of time that we have, I'll leave it right there for now.
Thank you. Before we run out of the time, there's another question raised by one of our participants, and that's about the role of local civil society in human rights organizations in terms of promoting compliance with the IHL, both on the part of the non-state armed groups as well as the state actors. If you could briefly comment on that issue.
Yeah, I think where we've seen the role of civil society being the most vibrant and the most active is in terms of documentation and preservation. Civil society organizations have often played I would say, the primary first responders to conflict and crimes in circumstances, especially where the state itself isn't doing an effective job with regards to the collection and preservation of information, and where international institutions are either delayed or don't have access to circumstances on the ground. So we've seen many civil society organizations, including the ones in Afghanistan, play an incredibly effective role in terms of being the first responders to when crimes have been committed, collecting information and reporting that information, and then also preserving that information for other institutions whenever they have finally come around to actually prosecuting these crimes, or when they have initiated investigations. So it's that preservation and documentation, it is those activities which civil society organizations often perform in the context of conflicts that have incredibly valuable or are incredibly valuable for the purposes of transitional justice mechanisms down the line.
Thank you very much, Nemo, for giving us the privilege to have you at this webinar. And I would like to also thank our participants who stayed with us through this webinar. Since we are already out of time, with that being said, I am announcing the end of this webinar. Thank you all for being with us.
And thank you all again for this valuable forum and for continuing this conversation, and in particular, giving me the time to speak to your organization and your esteemed participants on these issues. Thank you again.